representing here on behalf of the appellant this morning?
Yes, Your Honor. Adam Ludwin on behalf of the appellant.
Would you wish
Andrew
to
Corse.
reserve any time for rebuttal?
Yes, Your Honor. 5 minutes.
Okay, I will be your timekeeper. I'm going to be as quiet as you may proceed.
Thank you, Your Honor. Your Honors, and I'm distinguished to share your last day. Had an oral argument. There was a breath in there. It may have been a little slow, but your last day at oral argument was my first day at oral argument.
That is kind of interesting. That's the second time this morning that's occurred.
It's we're all
Welcome to appearing before us. You'll find that in the future you are appearing in front of, in my humble opinion, the best DCA in the state. So I think you'll enjoy the judges here. You're very well prepared and know what you're doing.
Thank you, Your Honors. Your Honor, the matter at the lower tribunal started from a simple contractual duty, albeit ill-advised, between a boyfriend and a girlfriend, where they bought a boat together. And like many disputes between individuals who were romantically involved, the matter became emotional, and in this instance, vindictive. The claim in the trial court was a one-count replevin claim, which requires the plaintiff to prove that they were the rightful owner and that the defendant wrongly detained the property.
Were there any counterclaims asserted below for any equitable lien, any form of equitable relief, resulting trust, or any of those equitable remedies for any of those alleged down below? I shouldn't say below, at the trial court level.
No, Your Honor. The initial answer in affirmative defenses was filed by the defendant pro se. We had moved to amend the affirmative defense, the answer in affirmative defenses, and to assert counterclaims right before the hearing on the motion for summary judgment. It was brought up at the hearing on the motion for summary judgment. However, the judge did not rule on that, and candidly, no, Your Honor, the court was not asked.
The court was told there was a motion filed earlier that day, but it was not noticed for hearing. The court was not asked to rule on a request to amend.
Your Honor, no, they were not specifically asked.
Let's go through a little bit of the timeline because I want to make sure that I have this correct. After the complaint was filed, an answer was filed pro se by your client, correct?
Yes, Your Honor.
And he raised that the certificate of title, I think it was, or certificate of sale, I think it was title, that it had been fraudulently filled out by Ms. Seaman, correct?
Yes, Your Honor.
About 5 months later, Ms. Seaman, through counsel, files a motion for summary judgment, correct?
Yes, Your Honor.
And then that was June of 2023, August of 2023, so about 2.5 months later, there's a response to the motion, and that is filed by you as counsel.
Yes, Your Honor.
The next day, there's an affidavit in opposition to summary judgment, correct?
It is technically the next day. It was about 10 minutes after the motion was filed.
Well, the record reflects it was filed the next day, but that's fine. The response to the motion and the affidavit appear to raise something other than what was raised in your client's pro se answer, which would be that there was another agreement, correct?
Yes, Your Honor. It does expound on my client's initial affirmative defense, but it does, the issues presented expand.
Well, it expands or it raises a new defense. Because I do not believe that the original answer asserted that there was another agreement that impacted the agreement on which she was asserting a right to an 11.
Well, the agreement that is discussed in the complaint is simply an oral agreement that was essentially fluid, as unfortunately many oral
It may
agreements.
not have been fluid, but did your client raise the fact that you're now relying on, which is, here's the full agreement, there's more to it, there's more. Does he raise that in his answer?
Not in his answer, Your Honor.
So, let's stop there, because that's the question. So in the affidavit that you filed, it is expanded, this idea that there's more, or another agreement, or more to the agreement, that's raised in the affidavit.
Yes, Your Honor.
Then, 3 weeks later, there's a motion to amend, and that was filed right before the hearing.
Yes, Your Honor.
And I'm now circling back. The court wasn't asked to grant leave to amend at that hearing. Correct?
Not explicitly, Your Honor. It was,
implicitly asked.
well, we had brought it up for
Judge,
the
we
court
need
to
to
address.
rule on this. We want to amend, we need a continuance of this hearing. There are things to do, we need time to do that. Was any of that argued to the trial court?
No, Your Honor.
All right, so what I'm looking at on this record is the defendant trying to avoid summary judgment on something that was not raised in his answer. And while you filed a motion for leave to amend the answer to raise it, that was not scheduled for hearing, and the trial court wasn't asked to rule on it or to delay the hearing so that the amended answer could be properly filed.
Correct, Your Honor.
Okay. I just want to make sure when you started going into some of the detail that I had the sequence correct. So now you can go ahead.
Thank you, Your Honor. The oral agreement that Your Honor referenced was initially brought up in the plaintiff's complaint. However, there are no specifics regarding the terms of that agreement, the breadth of that agreement, if you will. There was an oral agreement, and there was an evolution of that oral agreement between the parties. However, there's simply no specifics. The plaintiff argued.
You appeared in the case January 23rd. You filed a motion to amend September 20th of the same year, so about 8 months later, 7 months, no, 8 months later. So to the extent that there was more information relating to the agreement or some defect, wouldn't the time to have filed a motion for leave to amend the answer have been about the time you appeared in the case?
Well, Your Honor, yes, that would be an ideal time. There was additional information that I learned throughout the process, and my client is unsophisticated, as many clients are. Regardless, I did not see.
Isn't that the risk that pro se party takes when they represent themselves, that they're not going to do it right, they're not going to raise things they should have raised?
Yes, Your Honor.
And then you came into the case, and I don't know what your client said to you or didn't say to you, so I'm not trying to point fault specifically on not raising things earlier, but it is troubling that there's a motion to amend the day of the hearing, raising what appears to be new information that had not been raised by your client in over 8 months.
Well, the information had been raised in our response to the motion for summary judgment and the affidavit.
8 months after the answer was filed.
Yes, Your Honor. And at that time, I had not sought leave to amend because the discussion of the terms of the verbal agreement was ambiguous, and I had considered it really all-inclusive because it did not state where the beginning was, where the ends were, what was required to be paid, and when. There was also a number of misleading statements, like the fact that the vessel had been actually purchased for $62,000 when it had been purchased for $71,999 out of joint accounts between the parties. And
when a disagreement as to the amount doesn't necessarily have to be raised as an affirmative defense, because you deny that you owe this amount. You deny that, or your client would deny, we don't have an agreement, it's my boat, it's a fraudulent title. That's what he basically said, it was a fraudulent title. but he didn't travel on that theory in opposition to summary judgment.
Well, we did discuss that in the opposition to the motion for summary judgment. Your Honor, we discussed the fact that it was the verbal agreement that formed the basis, that if my client had breached that agreement and my client failed to make the payments to Ms. Seaman, then that would have triggered her right to transfer the title into her name and recover the vessel. However, that never happened. My client did not stop paying, and Ms. Seaman transferred the title anyway, which was the fraud that my client was alleging in his agreement. It was the fraudulent transfer pursuant to the terms of the verbal agreement between the parties.
I'm looking at the affidavit right now. Where does it say that she committed a fraud in filling out the title? Paragraph 12 just says fraudulently transferred title, but it doesn't say anything about it was somehow a fraudulent document that she filled with lies. And that seems to be the basis of what he was asserting in the answer, the original answer.
1 second, Your Honor. It's paragraph 12, Your Honor.
Yes.
It says, after the relationship ended, Ms. Seaman became angered that I had been dating other women and fraudulently transferred title of the vessel into her name in violation of our agreement.
And his answer says that she fraudulently, let me see if I can find it real quick. I think it was along the lines of, here we go, took title without his knowledge or permission and fraudulently filled it in her handwriting. Is there any allegation that the title is inaccurate in the affidavit?
Well, I think what my client's referencing is that she filled it out and transferred it, which she was only permitted to do if he defaulted under his obligations, and the text message provided from Ms. Seaman to my client, which was an exhibit to the response to the motion for summary judgment, specifically stated that I know that you're current on your obligations, but essentially the boat was in my name, inferring that she transferred the vessel. And then there was another text message from my client responding where he texted Ms. Seaman saying that the transfer was without his knowledge.
In his answer, does he say that she fraudulently filed it, wasn't authorized to file it because the agreement wasn't for a sum certain to be paid on a certain date, it was a payment plan?
He does not state that specifically, which I believe is ultimately why I moved to amend, Your Honor, for clarification to avoid any confusion. I believe at the summary judgment level, all facts and any inferences therefrom are to be interpreted in a light most favorable to the non-moving party, which is my client in this instance. And I believe that perhaps his answer was not ideally pled, but there are certainly inferences in there to be interpreted in a light most favorable to Mr. Corse. think as the important things here are the elements, whether Ms. Seaman was rightfully the title holder, which my client is clearly challenging, whether she properly transferred the title, and whether it was wrongfully detained. The second part is equally important, and my client not only paid for part of this boat because it was not purchased for $62,000, it was purchased for $71,999, money that came from his pocket in addition to the other payments that he made. And
So to go to Judge Casanueva's question, your client might have had a counterclaim for unjust enrichment, might have had a counterclaim for a breach of contract. There might have been some other things that might have been raised, but were not in his answer or before the summary judgment hearing, and they properly filed amended answer or counterclaim.
well, yes, Your Honor, those were not in a properly amended counterclaim, but it raises the question as to the detention of the vessel. He owns part of that vessel.
He let you know you were at 15 minutes. It's your time to use it. You're at 15.
Okay, thank you, Your Honor. He owns a portion of that vessel. At a minimum, $9,999 of that was his. And I believe that his detaining the vessel was rightful based on the fact that he is part owner of the vessel. Thank you.
Good. I'm feeling very nostalgic and this is I think you were coming on the bench right as I was leaving Judge Parker's staff attorney.
You're absolutely right. We were both younger then, weren't we?
You were figuring it out real quick, and I had a long way to go, so I appreciate that. Yeah, that was a long time ago, I guess, 26 years. Your Honors, I'm here today. I'm from the Florida appellate firm, Brandon Vesely. I'm here today with Shannon Troutman. She's my senior associate. I'm here with Glenn Goldberg, who is was trial counsel in this case. Your Honors, we're here on this replevant action. It's a very simple replevant action. My client had very few elements that she needed to talking about money that his client had paid. There's an affirmative defense of payment. How he's entitled to relief on his oral agreement. There is counterclaims and things that should have been raised and weren't. The court is correct on the motion to amend the pleadings. It was done an hour and a half before the proceeding. Counsel made it very clear that he wasn't pursuing it at that time. Page 51 of the transcript, after they had gone through the entire hearing. I don't know if you know Judge Ramsberger, but he's very, very careful to make sure that everything that's ever needs to be raised can be raised, and he goes back and forth and makes sure everybody has an opportunity to present stuff. And he asked Mr. Ludwin, any questions? Is there anything else he wanted to present to the court that day? And Mr. Ludwin said, no, Your Honor, I don't think so. So it never got raised. And then I know there's some case law out there that talks about how motions for to amend pleadings should be considered even if they're late filed. But you have an obligation to then present that motion, set it for a hearing prior to a final judgment, prior to notice of appeal, and that didn't happen. So it's waived. You can't pursue it. It's a done deal as far as that motion to amend the pleadings goes. There's case law right on point in case the court wants to know that. I can just cite it real quick to Your Honors. There's Mitch Auto Sales versus 14004 Northwest 19th Avenue, 347 Southern 3rd, 438. Another case is City of Boca Raton versus Ross Hoffman and Associates, 501 Southern 2nd, 72. And DePaulo versus Rollins Leasing Corporation, that's 700 Southern 2nd, 31. And those three cases stand for the proposition that if you have a motion to amend your pleadings and you don't pursue it or set it for hearing before the final judgment's entered, there's nothing the court can do about it at that point. So that's been waived. Your Honor, counsel wants to bring in and inject these arguments that his client had a right to argue that he was in good standing in some kind of an oral agreement. As we argued already, we believe it needed to be pled, but it wasn't. However, there's another argument that we raised in our response brief that if that agreement that he's talking about, $500 a month, were something that that the court should have considered, the Tipsy Coachman doctrine governs, because that would have been a violation of statute of frauds. You can't have an oral agreement for $500 a month that goes out for 10, 12, 15 years. It needed to be in writing, so the court would have been right for other reasons had that been the case.
Under the statute of fraud, is there any, I'm guessing it may not have been raised below any issue that partial performance might have taken it outside the scope of the statute of frauds, that is those sequential monthly payments?
These things weren't argued at all, Your Honor. I'm just saying from a Tipsy Coachman standpoint, we believe that would have governed. And again, you know, the defense of affirmative defense of payment is something that should have been raised if he was going to argue that he made payments and he was entitled to a portion of the vessel.
One issue that I'm concerned about is the replevant complaint says she is owed an amount of money that hasn't been paid, and therefore she's entitled to possession. The affidavit in opposition, if you cut through everything that's asserted in there, there's at least some implication that it's not due. I am not in default because it's not due. Is that enough to defeat summary judgment? And if the answer is no, it's not enough, why not?
It's not enough because that is a separate type, that's a separate agreement from what she pled, and he needed to plead it. He needed to plead that he had an agreement for $500 a month, he was making payments, and therefore those things weren't due.
But the complaint says defendant was to purchase the property from plaintiff in the amount of $62,000. Defendants in possession has failed to refuse to remit the purchase price. So again, $62,000. And then the affidavit in opposition says that there's this agreement, this other agreement that hasn't been pleaded. But it also says that I was current on my obligations. And I think somewhere else in there, it says that, I don't know, he might have not said it specifically, oh, here it is, I never defaulted under my payment obligations. So you have an assertion of non-default. Why is that not enough for the trial court to have to take evidence at a trial or further summary judgment proceedings with more information as to, I don't owe her this money, and she says he owes her the money. Why is this not enough in the affidavit?
If he raised that in the affidavit and it was attached to his motion, to his response to the motion for summary judgment, if he had pled that from the beginning, I think Your Honor would be absolutely correct. That would have been sufficient, but he wasn't. And that's why, even if the court were to have considered it, that's why we raise our Tipsy Coachman argument that statute of frauds would apply, because he's...
So it's the idea that there's another agreement that means I don't have to pay it now.
Correct. And payment, you know, affirmative defense of payment. I've made payments. I'm entitled to.
Well, you don't have to raise an affirmative defense if you're denying that you owe the money. I mean, you just file a denial, right?
Correct, but if you're trying to say that I made payments, I think you have to,
that there's a different agreement that alters my obligation to pay now.
that's right. Again, you know, this is purely a pleading issue. I mean, had they pled it properly, we wouldn't be here because summary judgment probably would have been denied at that point, but it wasn't pled. They relied on this one-page handwritten pro se statement, and then the allegations in that statement then changed by the time they got to the summary judgment. He's saying fraud. She signed it herself, and when he actually admitted in his affidavit that he endorsed it, and he turned it over to her. He gave her the property, put the title in her name, and they have.
Am I reading the affidavit correctly? That, I'm sorry, not the affidavit, the answer pro se. He doesn't deny owing the money. He doesn't assert that he's not in default. It looks like the only thing he asserted is that she fraudulently filled it in.
He asserts he's the legal owner and that she fraudulently filled out a certificate of title to herself. And that's not true because he later admitted in his affidavit that that certificate of title was endorsed by him to her. And I just want to point out that these claims that he's raising are not compulsory counterclaims, which means there might be an opportunity later on. But at this stage of the proceedings, it hasn't been pled. My clients had an opportunity to bring a summary judgment, to go through the elements of their case, to show that Ms. Seaman actually had title, that Mr. Corris didn't do what he was supposed to do, and therefore had no right to keep the boat, and that he was in possession of the boat. So based on those simple elements, I believe that the court should affirm. And if there's any questions.
That's it, you're so close. Thank you very much for your presentation.
Thank you for letting me be part of your final day, Your Honor. Oh, final oral argument. You have my permission to quit now if you want.
I'm sure you're going to try to survive this day, even right on your stay at home. Counsel, you have 4.5 minutes remaining.
Thank you, Your Honor. One of the things that I'd like to highlight on is counsel made the argument that statute of frauds would preclude the agreement because it was a verbal agreement. But that is the exact reason this unenforceable verbal agreement is the exact reason that they claim that they were entitled to transfer title of the vessel. So they're relying on the same agreement that they're claiming is unenforceable. As Judge Silberman also picked up on my client's answer, he did not go line by line and admit, deny, or say he was without knowledge. And it was tantamount to a general denial that he was responsible for payment. The issue regarding the agreements, that is one that the plaintiff was required to present and argue in their complaint. They simply stated that there was a verbal agreement. The fact that they're in the fact that there are additional terms, supplemental terms, this all leaves genuine issues of material fact open for trial. There was nothing in the counsel says if it would have been pled differently, it would we probably would not be here. But there was nothing in the order regarding any pleading or issues. The court simply said that the plaintiff had proved their case and the court weighed the evidence rather than whether there were any genuine issues of material fact, and found that she was the rightful owner simply because the title was currently transferred into her name. The judge did not give any explanation regarding the wrongful detention of the property. It simply looked back and applied the fact that the title was in her name, so my client must have wrongfully detained the property. There were also a number of false statements and misleading statements in the plaintiff's affidavit, which should render the affidavit questionable at best. She did not mention that the funds that came from the joint account, she never provided any evidence that she actually paid $62,000 for the purchase of the vessel. There was a bill of sale that had been filled out for a lesser amount, but my client actually produced the checks that showed that the boat was purchased for $71,999. Also, there was no discussion of the payment plan and whether my client had breached the payment plan. These are all genuine issues of material fact that should have precluded my client from having his day in court. And we would request that the court overturn the summary judgment and remand back down to the lower tribunal and direct the parties to proceed in accordance with instructions to be provided by this court. Thank you.
Thank you. Thank you both for your presentation. This act is on, I think.